All right, it's 1:30, and I'm just making the announcement that for a variety of reasons, we've decided to reconvene at 2 o'clock. This is primarily for the benefit of those who are watching us via the live stream. So we'll be back, and the commission will reconvene and conduct and carry out the rest of our business beginning at 2 o'clock.
Council Blue.
Good afternoon, Commissioners.
Good afternoon. Good afternoon.
At our last commission meeting, we heard from a number of our racing stakeholders, and after receiving comments, the commission asked us to go back and look at a number of issues. And so you have in your package today 3 memos that address some of the issues that were raised at our last meeting. The first memo is a memo on the Economic Assistance Fund. As you may recall, we had a request from the New England's Horsemen and Benevolent Protection Association for basically the balance of the fund from 2014 or for the entire fund, depending on how you read the request. We've gone back and looked at the fund. It's a $20,000 fund that's allocated each calendar year. The purpose of the fund is for people employed at the track in Suffolk County when they suffer catastrophic issues or illnesses, and we have consistently over time awarded almost the entire $20,000 each year. So if you look at the memo in your packet, what you'll see is that in 2014, we awarded about $19,200. There's roughly $800 left in the fund from 2014. And we do have claims coming in now. We've had at least one already in 2015. So it is the legal department's recommendation that you not use that fund for anything other than individuals who come forward from the track and who make claims for illnesses or other economic hardship, as we have used it in the past.
Comments, questions?
Yeah, I would agree with the recommendation. I've seen consistently how we've used that money. It's been an enormous help to people who are really in who have had a serious issue, and we have used that money consistently, so I would agree with that recommendation.
I would also. Do we need a vote, or we just?
I think you just need to instruct the legal department to respond to the Horsemen's request for that fund, and we will just send a letter to that effect.
Yeah, I think the Horsemen were not aware that we had used just about the entire balance of this money, so I think that they were...
In prior years, you mean?
Last year in particular,
right.
they thought that that would be money that would be available, and they were surprised to learn that just about all of it had been used for legitimate claims.
Yep.
Yeah,
I agree.
Sounds like a consensus, and and we're all coalescing around your recommendation.
Okay, thank you. The second memo regards the health and welfare benefits. So if you think back to our statute and our regulation, of the Racehorse Development Fund, 4% is dedicated towards health and welfare benefits as the fund is split between thoroughbred and standardbred. And the question
4% of each side's total.
Yes, of
right?
each side's total, yes. So we discussed this at the last meeting, and the question was whether the commission can and should pay those funds out. The legal department went back and reviewed that. We believe it is appropriate to pay those funds with a slight caveat, which is that the language requires that the commission determine how much of those funds should be paid to jockeys and drivers. So if you think about the overall fund, the fund is designed to cover jockeys, drivers, horsemen, owners. It covers a broad group of people. And it also says that the commission shall approve what piece of that fund gets paid to jockeys on the thoroughbred side and drivers on the standardbred side. The thoroughbred horsemen suggested that we go back to the racing committee and ask them to make that decision. It didn't seem to be within sort of the expertise of the racing committee. We think that we should do one of two things. We can ask the individual stakeholders what they plan to pay, or we can go out and get additional comment. And you'll see comments in your packet from the Jockeys Guild, who suggested that the payment should be at least what Suffolk Downs would have paid if Suffolk Downs had live racing. So right now, under our statute 128A, $65,000 each year is allocated towards jockey health and welfare benefits, and that goes to the Jockeys Guild. In years past, Suffolk Downs has paid anywhere between $20,000 and $30,000 on top of that, so they get approximately $100,000. And the Jockeys Guild has suggested that what the horsemen should contribute should be equal to what Suffolk Downs would have contributed. But we can also solicit additional comments or additional input
So
on
what
that.
so the horsemen would contribute 20 to 30,000 on top of the 65, which routinely comes from us?
Yes, that's
By
right.
our direction, yeah.
That's right.
But that's not, like, is that within our authority? Because I guess it is within our authority to direct that if we wanted to.
The commission needs to approve what is paid by each of the horsemen's group towards the jockeys or the drivers.
The statute says that, right?
Yes. Mhm.
But suppose the racing starts again, then 128A kicks in, right?
It would. On the thoroughbred side, it certainly would. And then Suffolk would be making some payment, or whoever the licensee was would be making some payment to that fund as well.
And so would we still have the obligation of ordering some portion of the 4% paid?
Yes, I believe so.
So there'd be three sources at that point
Yes,
for that fund?
there would be, yes.
Okay, because it's gaming license
Yep,
plus 128A.
yep. Plus what comes out of
Plus
the
what comes
wagers
out of
and
the-
the premiums from the
Section
track.
Yeah.
And what is the Section 60?
It's the
23K,
Racehorse
Section
Development
60.
Fund.
What does it say?
It sets up these splits.
The racehorse development.
Oh, it's these
Resource
splits.
development,
Oh, but what's
Yeah.
the third, so the third, but in the past, there's been two payments. One directed by us, which was 65,000, and another which we had to approve, which was Suffolk Downs paying 20.
No, we didn't
Oh.
approve Suffolk Downs.
Oh, okay, I
They
thought you
made
said we
it.
did.
So
Okay.
Section 60 now introduces what appears to be a third revenue stream, which is a piece of this 4% that is approved by the commission to be paid for jockeys and drivers.
And I guess what the jockeys are saying, start with the level fund us like we were under 128A
Yes,
as the first, first available monies to restore that funding level, regardless of what happens later.
that's right. I think they're proceeding on the assumption that if there is no racing, they would like to have a fairly level payment
Fairly
for
level
this year.
payment. Yeah.
Well, don't we have to wait to see what happens on the racing front before we can make that judgment then?
Well, this is the revenue.
We could. I mean, one of the interesting things, if you look at the comments from the Jockeys Guild, is they list what other tracks pay in total for this. And they have higher, or mostly higher numbers based on how they've divided up tracks. So it may be that, a little extra money wouldn't be a bad idea in a situation like this. I mean, Suffolk, in the tier that track was in, had some of the lower payments. There are other jurisdictions that put a great deal more money into this than Massachusetts does. So we could certainly wait until we found out, because we should know that hopefully soon. But we would need to instruct the various parties to let them know that we would be expecting some portion of that money to be paid towards this. We just haven't approved a number at this point.
Where did last year's 65,000 come from?
It's in the statute, 128A. And it's
128A.
been level.
Oh,
Yeah.
okay.
For a long
So
time.
that says 65,000.
65.
Yeah.
And now,
this is-
so
No.
I'm sorry, I thought I understood this, but guess I don't. So the jockeys are saying that they would like that 65,000, which is still
Which is still
required.
there,
Okay,
yes.
so that's got to happen.
Yep.
And then there is an addition, we have the authority to direct some portion of the 4%. That's additional.
That's correct, yes.
65,000 doesn't come out of the 4%.
That's right.
Okay.
Oh, I thought, I was also misunderstanding then. I thought the request was to take the Gaming Act, the 4%, and do that 65 or 100.
The 65 is in the 128A racing statute. It has been level for years and years.
Yeah.
So there are a couple of appropriations in there. The Economic Assistance Fund is one,
Yeah.
where they're every year, that money comes out.
Okay,
And it's paid by the track out of the takeout.
Out of the takeout, yes.
Right.
yeah. And if there's no racing this year, we'll feel that next year because these lags, the monies here are already The monies
That-
are available already for us.
Yes, that's what the Jockeys Guild is basing their request on. They're not asking for a higher amount in total. They're going on the assumption that if there is no racing, they would be about $30,000 short of what they normally get. And so they would like the horsemen to contribute at least that much, and the commission to approve a contribution of at least that much into that fund.
That's it.
Well, I agree with your recommendation that this is a commission decision, not a committee decision. I think that if we could put this out for comment, which will serve two purposes, we'd get more feedback from stakeholders. And secondly, it gives us the additional time to hopefully understand the thoroughbred racing environment, because it's my understanding that that has to happen this month, a decision, before the simulcast runs out. So we're really just a couple of weeks away from knowing the landscape.
Maybe.
Well, and that, you know, again, comments, rather additional input, I think would be helpful, as well as the time to understand the landscape and make a good decision.
When we could do that, we could go ahead and authorize the 65,000. So they get something now, and then wait on.
You don't need to authorize the
Oh, that's just gonna
65,000. Yeah,
happen.
that
Yeah.
happens
Oh, I
anyways.
So the jockey's letter was irrelevant. They didn't need to send us this letter.
No, they were trying to, what they were trying to show is what the total payment has been in Massachusetts to jockeys over time. So, you know, the shortfall that they would have this year, if there were no racing at Suffolk Downs, would be $30,000.
Right.
And they're just using that as an example as to what you may or may not choose to approve.
Right, but their
as
last
payment.
paragraph says, "We would respectfully request that the amount of money the commission does be held at the 65,000 level," as if we have to make that decision, which we don't.
Yeah, that one we don't, no,
Okay,
we
that's
don't
fine.
have to.
I don't think that's what they're saying. I had a lot of trouble with that last paragraph on it yesterday myself. And I think that what that last paragraph says is that with the 65 and what you authorize, we want to add up to, we want the 65 and what you authorize to add up to what we've been getting in the past, which is roughly 100,000.
Oh, I'm seeing,
That's the between.
I'm sorry, you're right, you're absolutely right.
No, I
Okay,
had to read it 7
yeah,
times.
okay. Yeah, you're right. Okay, so they know that they're getting the 65, they're asking us for the delta, you're exactly right.
Yes, that's right.
Okay.
So I like Commissioner Cameron's suggestion. Let's get some more comment on it. Let's wait. The package that they're looking for is around 100,000, but maybe more if we choose to up the total amount that they're getting to be commensurate with other tracks. And that's a decision that we would have to make. So let's get some more comment. Let's get a little bit more time. It's not going to make any difference. And then let's revisit this when we have a firmer idea perhaps as to what racing's going to look like on the thoroughbred side.
When does the 65 get paid? Or is it, hasn't been paid?
That I would have to check on, I don't know. We pay it once, I think once a year, but I'm not sure. We'll have to ask
Okay.
Derek. He'll
I do know, I mean, there is some time sensitivity in the sense that a lot of these accounts are actually running dry, and there are people that don't know whether they're going to have certain kinds of benefits. And the horsemen have talked to me about this, us about this. But I think if we could make sure the 65 goes out as soon as it can, immediately, if there's no reason not to, and then hold our fire on the 4% and get some other comment, because I agree, we don't have much feedback on this from other stakeholders. Yeah, okay.
Is there a separate issue to be tended to here with respect to the Harness Association?
So the harness needs to come back too. This is a first for the harness drivers because they didn't have this requirement that they have to tell you what they're going to provide to the drivers. So they have the same issue. They need to come back and provide us with some kind of information as to what they plan to provide to the drivers, and then you would have to approve that as well. This is new because of the Racehorse Development Fund, so it's the first time for both sides.
Could I amend my thought here? I have a hard time keeping these different accounts separate, but the health and pension benefits, as I understood it from Mr. Spadilla, they have an account that they may well not be able to pay to keep certain benefits flowing to people. And he said he's getting calls all the time from people saying, help, I don't know what I'm doing, what's happening here. And they were anxious to get this money as quickly as they could. Could we, say, send out 200,000 of the 262, which is the 4% for the thoroughbreds, and hold back the 62, and I just picked that number, but it's for the sake of discussion, hold back 62 to determine whether we want to mandate that some of that go to the jockeys to make up their request or not. That gets them some real money quickly that goes to their health and pension benefits, which really are, I believe, at risk, but still retains the option for us to do what the jockeys have asked for. Does that seem like a
We could, I
reasonable
guess.
approach?
Yeah.
It would be, the question would be what amount, right?
To hold back?
Yeah.
Well, I'm just saying, if the high end is 35,000, let's just make it, just pick a round number and hold back
70, whatever.
hold back
60?
62, just so that we get them. But I think they would be most appreciative, and frankly, I think we have a duty to get them the money as fast as we can. It's sitting there, and it's meant to be servicing these folks. So unless there's some reason not to do that, that would be my suggestion on how we handle that.
We would need to have a similar situation, I think, for the drivers on the standard bread side.
Yeah,
So, whatever, and I don't recall off the top of my head what the 4% is of their piece. It's
87.
much smaller, is it
87,750.
So as long as we allocated a certain portion for each fund to hold back and then
Right.
paid the rest, I think the commission could do that.
Well, does the jockeys letters only talks about jockeys, right?
Yes,
It doesn't-
that's
Because
correct.
they don't represent.
They
We
don't
know the
represent
drivers, but
standard.
does did the same model hold place?
Yes.
On the other
Well,
okay.
we'd need some more input into it, but I believe it does.
Okay.
They don't, the standard bread folks don't have an allocation by statute, is my understanding. So I would like to get more information from the standard bread folks on how they do it and how
Right.
it gets paid.
Okay. So if we did, basically paid out 80% of the 262, which is around 200,000, and paid out 80% of the 88,000, which would be 70,000, and held back the similar amounts for both, then we could resolve this in the next couple weeks.
Mr. O'Toole, do you have any thoughts on the harness side?
I have them back in the office.
Good afternoon, Commissioners.
Good afternoon.
Steve O'Toole, Plain Ridge Racecourse General Manager. Thanks for getting me out of the snow today. When I left, we're getting another couple inches. For the standard bread side, this will be a new adventure for them. They have a parent association called Harness Horsemen International, and they have, similar to the Jockeys Guild, they have coverage, which they do participate in now as far as liability, but they haven't participated for a number of years in the insurance coverages for health and benefits to that nature. So they'll be able to go back and start that again. So the initial funding would be, a good start for them to get rolling on that. So I think they'd appreciate the payment. As far as separating anything out for drivers and all that, that would be something they'd have to determine where this is all new to them.
Because that hasn't happened. There hasn't been a parallel structure in the past. Is that what you said?
They
terms
did
of
participate.
separate-
They did participate until the funding got so low they couldn't afford it any longer. So they do still participate in the HHI liability coverage, so that liability occurrences are covered. I think it's $1 million policy that the HHA buys through HHI to cover all their members in that respect. But as far as health and welfare benefits, they're not participating in that program right now.
Right.
But there is a program similar to the Jockeys Guild that's out there for them. They just haven't participated
Okay.
in probably the last half a dozen years or so.
And when they were participating, that reserve between the drivers and everyone else, how was it handled for the standard bread?
So it was equal. There was no carve-out for the drivers
There was no
versus the
carve-out.
trainers versus the grooms. It was universal coverage with pretty much all the same.
For
coverage.
everybody?
Yes.
Everybody the same?
Yes.
Okay.
Because the Jockeys Guild is more concentrated on the jockeys, whereas the national HBPA is concentrated with the horseman population. So the HBPA is the New England HBPA. They're an arm of the national HBPA, and I think they provide the other insurances for the trainers and the grooms and the hot walkers and things like that.
Which would explain this, the difference in the statute perhaps, Catherine, right? That there's not a specific
Yes. That's
carve-out,
definitely
if you
probably
will,
true, yes.
for the statute. Okay. Thank you.
So treating them equally for purposes of getting some monies out now, you believe would be appreciated by the harness horsemen?
I think it would, so they could start that process with HHI, start figuring out what kind of policy they could purchase and get that process rolling.
Thank you.
Thank you.
Thank you.
So we would look for feedback from the thoroughbred stakeholders.
Any
on the-
stakeholder, right?
But also, it's sort of inviting the standard bred people to take a look at this and see whether they want to have a similar model.
Yes.
Right, okay.
But we would still reserve 20%, I
Of
guess,
both.
right?
Of both.
Of both.
Right.
Even though, at least for the standard bred, we might not have to, because everything goes to the same
Yeah.
pool.
Right.
Until we have more comment, I
Yep.
think that's
right.
appropriate.
Okay.
So if you could vote to
Yeah.
approve the payment and holding back the 20%, then we'll get started on that.
Commissioner Cameron, do you want to take a crack at it?
So I move that we distribute a portion of the 4% for both harness and thoroughbred racing, holding back a 20% until we understand better the landscape. We also, well, that's a separate, the comment is separate, so.
Second?
Second.
Any discussion further? All in favor?
Aye.
Opposed? The ayes have it unanimously.
Thank you.
Thank you.
The second memo in your package deals with the payment of the 16%, which goes to the thoroughbred and standardbred breeding programs. We went back and reviewed that under Chapter 128, which is the agriculture statute, as opposed to 128A, which is the racing statute. The Massachusetts Thoroughbred Breeders Association is recognized as the association. They are recognized by statute. So the commission does not have to take any further action to recognize them. The Standardbred Owners of Massachusetts is the group that you have recognized in the past for the Standardbred owners, and they have submitted a request for this payment. So we generally approve them as the group for the breeders every year in front of the commission. So we believe that you could make the 16% payments to both groups. The Racehorse Development Fund says it goes into an account that they set up, each one of them sets up, and we could, with your approval, make those payments as well.
General Counsel Blue, we authorized, I was reading that in the minutes, we authorized 8%, because that's what the request was, and then, so do we have to amend that authorization that we?
Well, the 8% is a different number. The 8% is under the agriculture statute,
Right.
and that's the limit that they can use of their total for
Right.
marketing and other non-breeding activities. So I would recommend that we pay them the entire amount that's due under the racehorse development, subject to the fact that when we request that they show us documentation that they have not spent more than 8% on their marketing.
No, I
That
agree
matters.
with that. I just didn't know if we had to amend our prior motion, which authorized 8%.
Well,
I think we can do
it
it
was
here.
8 of the 16.
It was,
It was 8 of the 16, right.
Yes, but the 8.
but we're now going to give the whole 16, not just the
When
8.
they talked about the 8, they're talking about this separate part of the statute. I think they can probably use more than just the marketing money. The 8% is all they can use for marketing.
Right.
Our Racehorse Development Fund does entitle them to the entire 16.
Right. Yeah, I totally agree. I think we should definitely do that as soon as we possibly can. Any other discussion or different views?
And this is similar, right? It has the same split, the 75-25.
Right. It's $1,050,000 for the thoroughbred breeders and $350,000 for the standardbred. Commissioner Cameron?
So I move that we authorize the entire 16% distribution from the Racehorse Development Fund to the 16% to the Massachusetts Thoroughbred Breeders Association and the 16% of the split of the Standardbred Owners of Massachusetts.
Standardbred breeders, right? Yeah, owners,
Yeah,
that's right.
yeah.
Owners,
and
it's the
breeders.
name of the organization.
Okay. Second.
Now, what are we doing? The thoroughbreds, we don't know whether there's going to be a race or not. We don't have anybody to give purse money to, and we understand there may be a change in how the purse money is used anyway, directed to be used. But the standardbred, they're racing now. Should we be giving that 16? And it's certainly not going to go to less. It's possible we might decide it someday, or the racing committee might decide it someday, if there is no thoroughbred racing, to change the percentages. But at the moment, it's 75-25, and certainly standardbred isn't going to be going down. So should we not consider authorizing maybe we don't even have to authorize the payment to the standardbred purses?
Well, based upon the action by the commission today, we've now taken care of all of the breeding money and then all of the health and welfare money. It leaves only the purse account money.
Right.
And because the standardbreds are racing, I would suggest to the commission that we authorize making the purse money payments to the standardbred.
Right.
It goes into an account. They will have to enter into an agreement with their horsemen, as they always do, and they can determine how to allocate that money. But I think we should make that payment at this point.
Right, okay, good. Just out of curiosity, Steve, what if there's $2,187,000 in the Racehorse Development Fund that will come to the purse account? What does that do to your purses?
Builds them up.
Well, I know that. I mean, how much? How significant is that?
So it's very significant because going into this year, Penn National overpaid the purses last year about $850,000.
Wow.
So there's an ebb and flow to the purse accounts in good times and in bad times. So right now that flow is in the negative for the purse account. So this will help replenish that. We'll be able to start off maintaining exactly where we were last year, if not maybe a few dollars more. And then as handle increases the purses, handle money comes into the purse account, as well as operations that begin in June, sometime in June.
I misunderstood. You said Penn National, they had a subsidy of $850,000?
Correct.
Okay, and what was the total purse amount?
That we paid last year?
Yeah,
$2.3 million.
2.2. So this is almost doubling the total purse amount.
Just using the figures that are out there for projections and everything, it looked like about a $4 to $5 million purse account for this coming year.
Counting racehorse development money?
Yes.
Yeah, okay, so it's 40 to 50% of the total. Wow.
Yes.
So it's doubling.
Yeah. Well, that's great. I think we should get that out there ASAP.
Yes.
Commissioner
Thank you.
Cameron? Thanks, Steve.
No,
No.
that's,
No, I thought but we need to move to authorize the payment, right?
If you would. please.
okay, so I authorize that we provide the 80% purse account to the standardbred, to the, I want to
Purse
say
accounts.
it's the same.
Purse accounts.
It's the purse account money to the standardbred licensee.
Okay, so it's the purse account, the 80% to the purse account to the standardbred licensee. That's the,
Second.
Any other discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously. Great. So so we're still sitting on $6.5 million for the thoroughbreds, and we will await progress
And
for
we're
what
sitting
we
on,
do with that,
and we're sitting on 20% of the
20% of-
40, on the 4%.
of the four,
On the
right,
health and welfare. Yep.
right. Great, that's very helpful, thank you.
Next, in your packet, we have two amended small business impact statements. We've included the regs with them, but you have already approved the regs. They were just there for your benefit. These are the amended small business impact for 205 CMR 149, which is the Racehorse Development Fund regulations, and for the amendments to 205 CMR 134, which is licensing regulations. Once you approve the amended small business impact statements, we'll file these, and they'll be ready to go after they're posted. So we've been through the whole formal process with these.
I'm sure it's all right. Anybody, any thoughts, questions, issues?
Nope.
Do we have a motion?
Sure, I can move that the commission approve submitting the amended small business impact statement for regulations 205 CMR 149, the Racehorse Development Fund regulations, as well as regulations 205 CMR 134, the licensing regulations, as presented here in the packet today.
Second.
Any other discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
While we're doing small business impact statements, if we would just skip ahead a little bit, we have two small business impact statements. They're under the IEB section, but really, they're more legal department focused. These are the small business impact statements for 205 CMR 139 and 140. These are the continuing disclosure and reporting obligations and the gross gaming revenue and tax remittance and reporting. This will start us through the formal process on these regulations, so if you could approve the small business impact statements, we'll get that process started.
And these regulations we also approved last time, if I remember correctly, on the
Yes.
the taxes.
To start through.
The gross gaming revenues.
Yep.
And have been submitted.
Discussion? Motion, Commissioner?
Sure. I would move that this commission approve the submission of the small business impact statement on regulations 205 CMR 139, the continuing disclosure and reporting obligations of gaming licensees and qualifiers regulations, as well as the small business impact statement for 205 CMR 140, the gross gaming revenue tax remittance and reporting regulations, as presented here in the packet.
Second?
Second.
Any further discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
And then finally, under legal, we have for your consideration today a policy. This is one more of the pieces of our ongoing records management, overall records management type policy. And this is a policy regarding the removal of applicant materials from the Commission's website. We have a lot of the applicants' materials from the very first, from RFA 1s to RFA 2s, for both successful and unsuccessful applicants still on our website. And we wanted to put into place a practice whereby we remove some of those, we archive them. We certainly don't get rid of them or anything. We archive them, but we leave up just those materials pertaining to the successful applicants. And that frees up some space and then allows people to see what's going on with the current applicants. It also acknowledges that some of the other material, it gets stale over time. A lot of that stuff is now 2, sometimes close to 3 years old. So if we implement this policy, it will allow us to take some materials down, but we will still be keeping them in an archive.
And on an ongoing basis, your recommendation would be that when we make a decision, like a Region C decision, if we make one, that upon the decision, the materials would come down immediately for the losers.
I think we were going to leave them up for about a year for
Oh, it was a year?
unsuccessful. And then we would take them down. It does allow folks to go back and look at them. We do oftentimes get requests for some of those materials, so it just makes it a little simpler. We'd leave them up for a little period of time.
Well, it's
No,
it's
it
not
does
what it
say,
says here, but,
take it down upon the award of the license.
right,
On the award.
in the,
Right,
Okay, we leave the successful for you. That's
Successful,
correct.
right.
That's correct.
Successful stays up for the life of the license. The unsuccessful comes down with the award.
With the award.
I'm agnostic on the point. If you think it would be better to leave it up for a little while, I mean,
I don't think so.
Yeah,
It
okay.
will be available.
Okay,
As long as
yeah,
it's readily
right,
available. If
right.
someone asks for it, then I think we're fine.
okay.
Do you need a motion?
Yes, and then we'll add this to our list of policies.
Somebody?
So I move that we approve the removal of applicant materials from the commission website policy as outlined here in this report.
Second.
Is there any other stuff that we have up that we need to think about whether to bring down or not, that would need to follow a policy? I mean,
I'm sure there is. We should get with Elaine and have a conversation about
Okay.
what's there. We should give some thought to archiving certain periods of time
right,
that don't need to be as readily available, but can be available if needed. So it's something for us to consider.
right. Okay, any further discussion? All in favor?
great.
Aye.
Aye.
Opposed? The ayes have it unanimously.
That's all for legal.
Thank you.
Thank you.
Thanks very much.
We now get to item 7, the IEB Director Wells.
Councilor Blue, was there 205 CMR 151 part of the packet for a reason?
That was the thing, that's what came late.
It's the operations of the,
I don't see that on the agenda. Which one?
Okay, then
It was left on our places
it
when we
was left
came.
on our places.
Oh, the
The operations
operations
certificate.
certificate is
Operations and gaming
here. It's going to
certificate.
come up under IEB.
Okay,
Oh. Oh, 7C, that's right, yeah.
Yep.
Right.
Good afternoon, Commissioners.
Good afternoon.
I believe General Counsel Blue has just confirmed that she took care of Agenda Item 7A, the approval of that SBIS. So I will move on for the IEB section of the agenda this morning to 7B, which is the temporary license requests. So for your consideration this morning, I have 3 requests from Penn National for temporary licenses for primary vendors. The first request is for Konami Gaming. Konami Gaming was incorporated in the state of Nevada in January of 1997, is a wholly owned subsidiary of Konami Corporation of America, a holding company, which in turn is a wholly owned subsidiary of Konami Corporation, the parent company. Konami Gaming is a designer and manufacturer of slot machines and the Synchros Casino Management System for the global gaming market. Konami Corporation was founded in March of 1969 as a jukebox rental and repair business by Kagumasa Kazuki, the current chairman in Japan, and is currently a multidimensional Japanese holding company which conducts business through its various subsidiaries, which are publishers of toys, trading cards, anime, slot machines, arcade cabinets, and video games, as well as operators of health and fitness clubs in Japan. There are 8 entities which are deemed qualifiers under this application filing for Konami Gaming, as well as the investigation also extends to 8 individual qualifiers. Konami Gaming is currently licensed in at least 37 states and licensed by approximately 8 international gaming jurisdictions. Inquiries into various jurisdictions proved licensure by Konami Gaming to be in good standing. The investigation relative to the criminal, civil, and financial background of the applicant to date or its affiliated entities and individual qualifiers has not produced any information that would preclude a finding that Konami Gaming possesses the requisite qualifications for the issuance of a temporary gaming vendor primary license of the Commonwealth of Massachusetts. So the finding by the IEB is that it's reasonably likely that the license would be issued upon completion of the investigation presentation to the commission, and that's the standard. So I don't know if the commission wants to potentially vote on these separately, or I can go through the summary for each 3 of the requests.
you have 3 requests for
Yes.
gaming vendor primaries?
Primaries, they're all primaries. Do you want me to go through all 3, or do you want to do the vote
So
one
you
at a
have a
time?
short summary for all 3, just like the one you just read?
Correct, similar, yes.
Okay.
Okay, go through. The second request for temporary license, also from Penn National, is for Modern Gaming East LLC. Modern was incorporated in the state of New Jersey in January of 2005. Its office is located in Ventnor, New Jersey, and is primarily a sales organization whose members have a combined 44 years' experience selling gaming and non-gaming equipment to the regulated U.S. gaming market. Modern currently acts as a sales agent for gaming and non-gaming products, including slot machines, slot machine peripherals, and components, and will providing this type of service to Massachusetts casinos. The peripherals and components include LCD monitors, laser printers, and bill acceptors. Modern currently acts as a sales agent for Konami Gaming, which I previously spoke about, in certain states, and intends to act as Konami's sales agent in Massachusetts. All agreements with casinos are entered into between Konami and the casino. Modern acts as the sales agent only. In its entirety, the Modern Gaming application consists of 1 entity qualifier and 2 individual qualifiers. Modern Gaming is currently licensed in at least 7 gaming jurisdictions, and inquiries into various jurisdictions prove licensure by Modern and its qualifiers to be in good standing. So similar to the Konami application, the finding by the IEB is they're reasonably likely to be licensed upon completion of the investigation and presentation to the Commission. The third petition for temporary licensure by Penn National is for Ainsworth Game Technology. The specific entity seeking a primary gaming vendor license is Ainsworth Game Technology, Inc. I'll refer to as the applicant. It was incorporated in the state of Florida in 2006, has a current principal business address in Las Vegas, Nevada. It is 100% owned by AGT Party Limited, a non-trading Australian proprietary company incorporated in Newington, New South Wales, on February 15th of 2001. AGT Party Limited is wholly owned by the parent company Ainsworth Game Technology Limited and serves as a holder of investments of international companies. Ainsworth Game Technology Limited is an Australian-based manufacturer and supplier of gaming machines, software, and associated gaming-related equipment headquartered in New South Wales. Ainsworth Game Technology is a publicly traded company listed on the Australian Securities Exchange under AGI and registered with the Australian Securities and Investments Commission in 1995. The applicant, a subsidiary of Ainsworth Game Technology Limited, provides sales, marketing, distribution, and technical support of slot machines and related equipment to casinos in the Americas. The applicant registered as a foreign corporation with the Massachusetts Secretary of State on April 10, 2014. Along with the applicant, 2 additional entities and 9 individuals have been determined to be qualifiers. While the applicant, which is registered, qualified, or licensed by over 100 agencies and jurisdictions, including Pennsylvania, Ohio, Missouri, New Jersey, and Nevada, is reasonably likely to be licensed upon completion of the investigation. There are certain historical issues which the IEB has identified and will thoroughly review and investigate, which include information from 1981 to 1984, the criminal history of Ainsworth Game Technology Limited CEO and current qualifier, related to issues in the Oregon Tribal Gaming Commission. That is approximately 31 years old. So subsequent to that, in 1997, the Colorado Limited Gaming Control Commission issued a notice of denial against Aristocrat's manufacturer and distributor license, in part because of Leonard H. Ainsworth's influence on an association with an aristocrat. In August of 2008, there was an issue where the Oregon State Police found Ainsworth Game Technology Limited not suitable to do business in Oregon in August of 2008 based on information about one of the principals. The company challenged the finding and in August of 2010 reached an agreement with the OSP and Oregon Department of Justice, and the OSP subsequently has withdrawn this finding of not suitable and replaced it with a revised determination which clarifies the ability of each tribe to enter into a contract with the company. And then in 2011, the Missouri Gaming Commission issued an order of a denial for Ainsworth Game Technology and found 2 principals unsuitable for licensure. After an appeal by Ainsworth, the Missouri Gaming Commission ultimately approved the application in 2014. So there is some historical information there. However, based on the current status of licensure of the company in numerous jurisdictions, it's reasonably likely that they will be issued a license by the commission, but I wanted to alert the commission that we will be looking into these issues and confirming there's nothing that the commission would need to, it would rise to the level the commission would want to deny the license.
So Director, you're asking for temporary licenses
Yes.
for these 3 entities?
Correct. Well, Penn National is, where the finding is that they're reasonably likely to be issued the license.
And you've looked at Ainsworth enough, you feel like, to recommend them at this point, but you'll be doing more work?
Correct.
What's Ainsworth's role? What are they related to Aristocrat?
Yeah, there's a connection. I don't know, do you know the specifics on? I
Are
think
they
there.
a sub of Aristocrat?
Well, no, I think there was one of the principals had worked at, I can't remember if it was Ainsworth came before Aristocrat, or Aristocrat came before Ainsworth, and then.
Ainsworth was Aristocrat.
And they were at the same time, and then there was a split off. So they're connected historically, but now they are two separate
I
entities.
see. I see, okay.
And what does Ainsworth do? Remind me again. What kind of
They-
equipment, similar to Aristocrat? Is this
Yeah, so they're
Sort
both
of
the primary
technology?
vendors of the gaming equipment.
technology for gaming equipment?
Great.
And the problem in the 80s was with Mr. Ainsworth?
Correct.
And-
I want to make sure I'm not disclosing information that may potentially should be redacted in a public setting. But that was, there was let me make sure I'm expressing this correctly, a criminal history issue of an individual who had the connection with Ainsworth Game Technology. But it's very old history.
Is the same,
But we don't know who the individual was. I mean, you may know, but
Right.
you're not saying who the
well,
individual
you
was.
did, you identified just now, somebody named Ainsworth.
No, it's got a different name. I don't know if I should check with legal whether, at this point, I'd prefer to,
This it sounds like a criminal history issue, which we would obviously redact in a report we were going to do. So I think what is important for the commission to know is there does seem to be some sort of issue. It is very old. The IEB will need to look into it to determine that it has no ongoing impact. But the request, I believe, Karen, is that you, for a temporary license subject to IEB further investigation.
And I know Penn made these applications. Do we know, or have we heard from Penn that they plan to do immediate business with all three of these?
yeah, so I had requested from Penn a list of the primary vendors that they planned on doing business with, and these were included in that list.
And if we were to wait until you complete the Ainsworth investigation, that would put them at a competitive disadvantage?
Correct.
That would put Ainsworth or Penn, or both.
Yeah, I would say both.
Did Ainsworth have time to get their application so that they could have been properly checked?
Well,
Why do we
well,
not?
it takes a long time to do the full investigation, as you know, for a primary vendor. I'd say it's a step down from these license investigations, but that would incorporate travel to other jurisdictions to look at information and interviews with qualifiers, so
When did you get their application?
I don't have the date
More or
of the
less, I mean-
transmittal.
Pardon?
I don't have the date of the transmittal. I would say
More or less, I mean.
months,
Months ago?
but maybe, I'd have to look at the.
So
at the
you're not
record.
asking for a temporary for them because they
were
weren't
late.
timely, because they were,
No,
didn't
no,
get
no.
around to-
All of these primary vendor investigations, the expectation is these will take many months, say 6 to 9 months potentially to do, depending on the volume and what else the IEB has going on at the same time. My expectation is that all of these vendors are going to be requesting temporary licenses and potentially getting them if it's appropriate, before the investigation is complete. So this is no surprise. It's not as if they're getting a temporary license because their investigation wasn't done in time or there's some delay by either the applicant
Okay.
or the commission.
Well, go ahead, whoever starts.
Yeah, the gaming vendor primaries, so we're expecting, and hopefully Penn has shared this with you, that there's going to be an ongoing business relationship with these folks
I would
proceeding out
expect-
past
Yeah,
their
and
opening date?
There may be, for example, maintenance of machines, or they may buy more machines, or new machines, or trade out machines, those kinds of things.
I mean, it's less of a risk, I think, at this category that we do the temporary, they come in, do the business,
Yeah, right.
and walk away before we conclude the
Right.
investigation. Okay.
Well,
Yeah.
they,
I was going to chime in. I, for one, am comfortable with, with the recommendations for the temporary license, even with this historical topic on the last one.
Right.
I don't know if my colleagues feel differently, but I'm prepared to act on the recommendation of the IEB.
Well, I think we've routinely received very sound recommendations from the IEB, and the fact that they are licensed in over 100 jurisdictions, is probably part of the reason why you're making this recommendation to us, so
That is correct.
I am comfortable as well with the recommendation, and the full investigation will take place, and if something changes, you'll advise us.
Yes.
I agree. I would move that the commission approve temporary gaming vendor primary license for Modern Gaming, Konami, and Ainsworth Game Technology, Inc. Did I get all three names right?
That's correct.
Second?
Second.
You know, I tend to agree with the commissioners. It feels that story, going through the story makes it feel like there's
Right.
a company that's got some things that are fast and loose. But I think if you recommend it, then I think it would be, I think it's appropriate to go along with your recommendation. Any other discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
And I would just add that I think the record ought to reflect that there's no individual names that have been indicated as the individuals who had some troubles in the past. That's
Right.
yet to be determined. We don't.
Correct.
We don't. That's not anything the commission is. It's any part of the commission's record, and whatever individuals are perhaps involved in something is yet to be determined.
That is correct. Thank you. And if the commission will indulge me, I realize it's not on the agenda for today, but it's something that was not called it to my attention till about 4:10 or 4:15 yesterday afternoon. I thought the commission may want to be aware. As to Region C, the applicants for licensure, for casino license in that area, I did, as the commission knows, the deadline for submission of all the materials for the RFA1 application, including the BEDs and PhDFs, for the qualifiers, identifying the operator, the equity, and the entire structure, are due on the 16th. That's what the commission decided. I had reached out.
I'm sorry, what was that date again?
The 16th is when
March
the,
16th.
March
basically,
16th.
March 16th is when the full application is due. So they have to provide their structure, they have to identify their operator and identify their equity contribution for the project. And I had sent deficiency letters to 2 of the potential applicants for that due date. Received, in that letter I sent to the Crossroads application, I indicated, we had conversation, said that there's information missing, and we had spoken and scheduled a scoping meeting for tomorrow, March 6th, and in the letter I had indicated that materials identifying what the structure is and identifying their qualifiers should be submitted to the IEB on March 2nd, which was Monday. I got a note from, an email from the lawyer for Crossroads indicating they wanted to postpone the scoping meeting till the following week, which on the 10th or the 11th. I responded back to the attorney indicating they had missed the deadline for submitting materials to the IEB for us to review, that March 2nd deadline that I had set, and I indicated if they would provide those materials by I think 4 o'clock on Wednesday, yesterday, the 4th, that I could postpone the scoping meeting till the Monday, what's the date on Monday? Pardon me. Monday, March 9th in the morning. I did receive an email back from the attorney that reads, Karen's, my clients were not able to finalize their agreement by your 4 o'clock deadline. No further information. So I just wanted to bring that to the commission's attention, if the commission wanted to weigh in or give direction on what you'd like me to do at this point. We do, the procedure has been that the applicant for all our licenses provides information to the commission so that we can do a scope of licensing process and identify who the qualifiers are, write up a letter to give to the potential applicant, and then that is the basis for their submission on any particular deadline for applications. So I'm in a bit of a bind here because I don't know if the commission wants me to extend the internal deadlines we have, or if the commission has a position on that. The problem, we have is that staff needs time to review the submissions they give us, then we have to schedule the meeting, meet with the applicant, and then after that, we have to draft the letter back to the applicant identifying the qualifiers, and then after that, they have to make sure that all their applications meet the requirements of the scoping letter. So that's the process, and I just wanted to bring that to the commission's attention in case there's any comment or direction you'd like to give to me.
Well, it seems to me that as we look at the structure, and I don't think we've discussed this before, but the deadline for submission of materials is the deadline that the commission sets, right? That's been true in every case. And what the IEB has done with the scoping meetings and the like is provide a service to the applicants so that the applicants will have an understanding of what stuff has to be turned in by the deadline. And it seems to me that the IEB has extended itself and has set the internal deadlines that you just discussed so that the applicant will have the opportunity to fulfill its obligations in giving the IEB a full list of things when the deadline for submission arrives. If the applicant chooses not to comply with the IEB's request for information and meetings and the like in a way that gives the IEB a reasonable chance to respond, then when the deadline arrives and they submit materials, the IEB may go through them and find that they're still incomplete, and that, in this case, is the end of the game. So it seems to me that you've set now a deadline. You can do what you can do, what you choose to do. This is one approach. I'm just thinking out loud here. You can do what you can do. You can do what you choose to do. But if in the end their materials are incomplete, that's the end of the ball game. And and if it's incomplete because they didn't talk with you beforehand and give you an opportunity to tell them what you need, that's on them. That is how.
I agree entirely. I think your characterization of the service is key here, and that's something that you have been doing quite a bit, trying to anticipate who needs, trying to anticipate questions, who would need to be submitting those PEDs, which are lengthy in nature, and thus the service. But the deadline is the deadline, and it's still in the future. I suggest you see what happens when that deadline comes to fruition.
Yeah, I hadn't really thought about it that way, but there's no requirement that they have a scoping meeting. If they call you up and say, we don't want to do a scoping meeting, we've done this many times, we know who the qualifiers are, and they bring and what the structure, what you're going to need, and then they submit it, and in fact they do, there's no harm, right? No, they don't. Jim characterized this as a service, and although you really want them to do it so that everything does in fact come in on time, if they choose not to, that's fine, right?
You could deem them. You could at the time deem them to be incomplete, just like Commissioner
16th.
McHugh. Yeah, Commissioner McHugh has suggested
Yeah,
as a possible scenario.
Yeah, I think just at the practical of what happens if they submit and there's one individual qualifier where they really, I look at it, when the IEB does an evaluation and, we would have had this person be a qualifier. Does that knock them out of the box? Or do we say, okay, we'll give you a little time because it's only one qualifier? Yeah, that potentially creates some confusion, but I think that the solution that Commissioner McHugh has suggested is definitely workable, and that helps me.
And you do have to come back after these deadlines and
Yes.
tell us whether they are substantially complete or not. That is,
Right.
that is a judgment you've had to make
Right.
In the past.
repeatedly, right? So you're perfectly capable of doing that.
Yep.
And then we can agree or not.
I think what you're hearing is they've had opportunities to work with you, to receive the information they would have needed to do this in a complete way, and that we're not going to necessarily be sympathetic to a very limited submission at this point, because they've had many opportunities to put the whole package together and to speak with you and use your services. So I think the deadline will be the deadline, and as far as I'm concerned, that there won't be a lot of room for a less than substantially complete submission at that point.
I agree with my colleagues. I guess the question is, do you want to take the time that they've asked for next week to sit down with them as close as they are to the deadline of the 16th and spend time with them?
Well, I would want to see their submission first. That's why I'd requested that, to see if it is a good use of the resources, because obviously we have an enormous amount of work going on right now, so I'd like to see the submissions and then schedule that. But, I've been readily accessible to all the applicants, so I'm never going to turn anyone away that is needing help. That's just, how we operate, but it's obviously frustrating.
At this point, they're not even asking for next week. You
Well,
offered next week, and they said they couldn't meet the deadline, correct?
They had asked for the 10th or the 11th. I responded, if you can get your paperwork in by the 4th, I can meet with you on the 9th. And they said they couldn't make the deadline of the 4th, and that's how it was left.
So the ball's in their court.
Correct.
Yeah, and Commissioner McHugh said how you choose to handle it is up to you.
Okay.
And I agree with that. Okay.
Okay, that's
So,
all I have. Thank
got
you
what
very
you
much.
Thank you.
All right.
You've got the, you're doing the regulations or group?
All right, we are now at item 8.
We're still on item 7.
I take that back.
We've got
We're still
letter
on
C,
item
which
7.
I actually,
7C, right, okay. Right.
Good afternoon, Commissioners.
Hello?
Good afternoon.
Before you is a draft of a regulation which you're seeing as a group for the first time. It's 205 CMR 151, dealing with the operations certificate for the gaming establishment. And the statutory authority for this regulation derives primarily from Section 25A of Chapter 23K. And this draft was prepared with the collective efforts of Bruce Band and Todd Grossman. There are 5 sections in the regulation. The first states that before opening, the gaming establishment has to request and obtain an operation certificate from the commission, and the certificate issues only after the commission conducts all of its reviews, tests, and inspections that are required by law, the regulations, and required by the commission. Also included in the first section, in subsection 3, is a non-exclusive checklist of items that the IEB will review, inspect, and test, including the licensee's system of internal controls, their compliance with 23K. There's a requirement that each licensee provide a complete list of employees, a confirmation that the gaming area and other non-gaming amenities are built to a superior quality, and confirmation that the license, all of the conditions of each of the gaming licensees' license are met, and that there is an emergency response plan on file with the fire and police departments in the host community. The second section requires approval of the gaming establishment floor plan of the gaming area, simulcast area, and restricted areas, specifically to confirm the security features, and this is a requirement of Section 25C of 23K. And this section specifies what needs to be included on the layout of the floor plan, such as equipment positions and the location of security features, as detailed in subsections A through U. The third section addresses the test period during which the IEB assesses compliance, including the IEB notifying the licensee of the schedule and the terms and conditions of the test period. The fourth section states that the operation certificate itself, once issued, remains in effect for the duration of the license, and the licensee must operate in accordance with the terms of the certificate. And the fifth section addresses amendments to the operation certificate and outlines a process whereby the licensee may petition the commission for amendments. So that's a summary of the regulation before you, and Bruce Band and I will try to answer any questions that you have. We will be asking that this enter into the formal process at this point.
Questions?
I had quick comment and a quick question. In 15101, this is being maybe a little bit too detailed, but the second sentence in that paragraph doesn't make a lot of sense.
Subsection 1 of the
Yep.
011. The operation certificate
Shall not issue
shall not
until-
issue until the commission has,
Just- I think it's just a wordsmithing that,
okay. We'll
Again,
take a look at that.
not to be that too detailed about it, but can you help me out under, can you just walk through 15104 subsection 1? Help me understand the timing of when an effective date would be established. You touched on it, but
This is reimbursements.
I think this would be set up and stuff during the meetings with Penn in the development stage. We'll be having now between opening and what we would expect in a test period.
Okay.
With live slots, it would probably be, real coin being played, but how we'd monitor their system and everything. Table games in the next opening would be a little more detailed.
Okay. So, and it's from effective date, point A, carried through whatever the life of the license is,
Yes.
5 years or 15 years? Okay.
Others? What exactly does the test period consist of?
The test period, it really gives us a chance to look at them operate. Historically, at various casinos and jurisdictions that we've dealt in, some of the properties have had trouble like balancing their banks, they can't count their money properly, and these are things that we want to know before we issue a license. There was one property in New Jersey, it took them 3 weeks to account for $600,000 that was missing. It was locked in some room that nobody knew about. It's little things like this that when you get close, sometimes they're not quite as ready as you'd like to look at. From a regulatory standpoint, we want to know they're on solid ground, they've properly trained all their people, the surveillance people know their system, and
But how do you do that? How do you?
you actually put people in the areas to observe. It's almost like a continuous audit. The end of the night, you actually let them go through the count process, make sure they can balance all the
So this is
banks.
like a soft launch? You have
Yeah.
you have customers there?
Yeah, yes, you do. With a slot parlor, it's a little different than a mixed one. A
Yeah.
slot parlor, it all has to be live money because of the slot machine. If you had table games in the mix, you would actually have what we'd call play money, so it wouldn't really count, and at least at that point, we could test the dealers to see if they could catch people cheating or anything like that. So it's to test the system, see how well trained they are and
Okay,
how ready they are.
but so you actually bring real people in this
Yes.
case, for some number of hours or days or something?
Yes, and that's what we would set up to determine.
Okay,
And in the scheme of things, let's say if you did it for an 8-hour period, you'd want to see all their shifts during that 8-hour period. For, somebody didn't bring in their strongest team just for us to see, we want to see everybody.
right,
So,
right.
How long is that test period typically, Bruce?
usually for something like a slot power, I would envision it being 1 or 2 days, unless we encountered problems. And at which point they would have opportunity to rectify the problems and let us look at it again. I don't foresee that in this case, but you just never know for sure.
Now, many of the requirements in this first section are, pointed to, you cannot operate until you get the certificate, and to get the certificate, you have to have done all these things. Many of them, or some of them, way in advance of, say, even a test period, like the system of getting approval of the system of internal controls and,
Yes.
all kinds of other things. I'm not suggesting, any of these should be in regulations, but have you get a sense as to how soon, how early certain things have to fall into place so that test period and eventual
Yeah,
opening can happen?
from a regulatory standpoint, I certainly would like to see those fall in place as soon as possible. But these things sometimes take a little longer than you anticipate. I think everything in this is certainly doable, and they're working towards that now, so.
Great. Great. Well,
Commissioners, I might add that I did because we wanted to make sure at least Penn is the one that's coming up for opening. So I checked this set of draft regulations with their compliance people too to see if they found any particular problems. They made 2 suggestions and we corrected those.
okay.
Good.
Real-time comment.
Yeah. Okay, any other,
So we need a, oh, I'm sorry.
any other questions or thoughts?
This is a submission to start the formal process?
That's correct.
Okay. So you need a vote?
We need a vote.
If there's some more comments, I'd be happy to make a motion to start the formal process of promulgation of regulations 205 CMR 151, the requirements for operations and conduct of gaming at a gaming establishment as submitted in the packet here today.
Second. Any further discussion? All in favor?
Aye.
Aye.
Opposed? The ayes have it, surprisingly unanimously.
Thank you.
Okay.
Thank you.
Thank you.
And item number 8.
Commissioners? So,
Good afternoon.
Good afternoon.
good afternoon. So I want to step a little bit out of turn. You know, generally our technology presentations and stuff we talk about is dry, so I can't imagine that many people are tuning in, but there is one person that tunes in that I want to say hi to. Hi, Mom. My 93-year-old mother makes it a habit of tuning in when I'm on the agenda,
Great.
so I wanted to acknowledge that.
Great. Welcome.
So I'm here to update you today on a number of things. I think the first thing is our support of the process to try to get Penn open and not to be in the way of that. And there's some things that have to happen. Oh, we're doing regulations first. I'm sorry. Let me take a step back. We are proposing a softening of the regulations that we promulgated related to the gaming standards. And after discussions with licensees and some of our vendors, including GTEC, it became apparent that some of the requirements that we had put in the original set of regulations were too tight and maybe even didn't allow for proper competition or mix of games on the floor, and really weren't providing us as regulators with any substantive additional information that we're going to need to regulate. So the language here proposes that we soften the requirements for, not soften, but define them a little bit differently. We require G2S or SAS protocol, but we've taken out the date and some of the restrictive language. So I think that is the essence of what the change is. I think it's going to be perceived favorably by all concerned, and I would recommend that we move that forward. In addition, we did take a look at language related to progressive slots and kiosks that Bruce Band had brought forward from New Jersey, and upon review of that additional language, it's covered by the GLI standards that we adopt by reference for those particular areas. So we did do the review, we sat down, we looked, and there was not anything distinctively different between the language that Bruce brought that we were looking at and regulate the standards which GLI put forward in those two areas. So it's on the agenda, but we chose not to make any changes to our regulations related to those two things.
Okay. Discussion?
So where are we with these regulations now that we're amending?
So the language you see here is the first pass in the process to make the changes that I just kind of highlighted.
Okay, so these regulations are not in the formal.
No, they are regulations. These
Yeah,
are
have been promulgated.
changes to regulations
I'm sorry,
that are
that's right.
promulgated
That's right.
and already filed.
So we need to put these changes through the formal process.
Indeed.
All right. I had just one question, and it really isn't about the regulations, about my understanding of the CMS.
Okay.
The first sentence of 4 says near real-time stream of data. There is a lag there?
So
This is a
data
technology question, not a regulatory.
Yeah, so I think near real time, when we first put our regulations together, some of the conversations we had with GLI when the words real time were in,
Right.
I think I was convinced that near real time was the appropriate way to put it because there is some latency and information is passed to multiple levels. Information is stored at the game. If the game loses connectivity with the site controllers which collect local data, then that, until that connection is restored, the data is stored at the game.
Right.
And then subsequently from that, at the local level, if the site controller, which is collecting the data from the machines, loses connectivity with the central management system, that data is stored and forwarded when connectivity is replaced.
Got
So that's the reason for making the nuanced distinction.
Okay, thanks.
Okay.
Anybody else?
And the way this language is written, you've let it, it's broad enough, but as long as it's compliant, the communication protocol is compliant with the central monitoring system, then we'd be okay. Is the way am I reading this properly here?
I
What's
think
in
industry
red?
standards is what we're saying. There are 2 industry standards. We will accept either one of them.
But if we don't have, or if we sunset the central monitoring system, would this be moot?
I don't think it would have an impact.
Okay.
Anything else? Do we need a motion to start these in the process? Commissioner McHugh?
I'd move that the amendments to 205 CMR 143.01 and 143.16, as those amendments are contained in the packet for today's meeting, be approved by the commission for commencement of the formal adoption process.
Second.
Any further discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
All right, thank you very much. So on the second item, we're going to talk a little bit about the Gaming Technology Laboratory and an update on that. We just talked about the regulations, and what we have to do with the Gaming Technology Laboratory is stand up business processes that enact the regulations, operationalize them, and allow us to work with our licensees, the manufacturers, and the labs. And so in February, we put out a draft of those business policies and practices for comment. And what you have in your package is that initial draft along with feedback and our response, similar to the way we did it with the regulations. But as we did this process, one thing became apparent. Getting that full document vetted and in shape, we weren't going to have time to do that before we needed to certify laboratories. So we pulled out the laboratory certification piece of that, finalized it, and earlier this week we posted the requirements for an independent laboratory to become certified by the Commonwealth, along with applications on our website. And we expect that the qualified labs that do this type of work will apply in short order. Actually, I've asked for those applications by mid-next week. There is a new form associated with those, the MDC vendor background investigation form that was created by Loretta and the IEB team, and that will be the information which we use to do the background check. And I expect and I hope that we'll be able to get enough information to bring qualified laboratories back before you on the 19th in 2 weeks to certify them contingent upon the outcome of the more detailed background investigations. The laboratories that do this work are certified in literally hundreds of jurisdictions around the world. And I really find, just based on my dealings with them, I don't think we're going to find something in their background or in our investigation that's going to cause us any real concerns. But having said that, we have a process, we're adhering to it, there'll be an application along with a fee, and I hope to bring those that back. The reason for doing this in such an expedited way is that we need the services of these laboratories to support Penn in the opening of Plain Ridge Park Casino. We need to engage them to help us get through the process and with some workarounds, because the full business processes that we're looking to stand up, we're not there yet. So that's the reason for doing the certification. One of the issues, one of the challenges with supporting Penn's opening is getting product, the electronic gaming machines, into the Commonwealth prior to our permitting process, our certification and permitting process. So we've answered a lot of questions of vendors who are selling to Penn about how we're going to do that. I've asked Bruce to sit at the table here and talk with the, and answer any questions, but we will stand up on the website next week the workaround process to allow devices to be brought in. So I think, and Bruce, correct me if I'm wrong, if a manufacturer has been licensed by the commission, as you did with Konami and others today, Bruce and IEB will work to bring machines that have not yet been certified and permitted into a secure warehouse here in the Commonwealth to allow the timing and the logistics of building the gaming floor to happen. And then subsequent to that, we will work on the permitting, the certification and the permitting of these platforms so that gets done before opening. And that's where we'll work with the labs. So I hope I haven't confused you with kind of a roundabout explanation of why we're moving quickly to certify the labs and how we're supporting Penn's opening. So let me stop there and entertain any questions about that.
If you bring, if these machines come into the Commonwealth in the fashion you've just described, what's tested is a specimen of that machine, not every one of those machines.
Correct.
Right?
Correct.
And so the testing can go on at the certified testing, independent testing lab of the specimen machine, the programs, the coin changers, all aspects of it. And then the certification comes, and all machines that meet the specs that were tested then are approved and can be deployed. Is that how this works?
Yeah, so in a lot of cases, these because we adopt GLI standards almost in their entirety as they're written, the machines, our standards are similar to the standards of other jurisdictions. So in some cases, it will be a transfer of certificate. The testing has been done for that particular platform version of software. It won't, GLI or BMM won't have to do it again. They'll issue a certificate that says this machine has been tested to meet. But the way our process works, we will take a certification from the lab that the platform meets our standards. We will then permit that particular instance or configuration, and then vendors can sell, and then individual instances of the asset would be registered with us.
Right.
That's the way, those are the terminologies, that, not to be confusing. Certification says it meets the standards. There is one additional test which we need to decide where that test takes place. It's the interoperability test that says that machine, that particular configuration, plays nice with CMS, works, plugs into our system as well as the house system. I think we're going to figure out where we do that. One of the reasons for having a gaming lab at our headquarters is to do some interoperability testing. I'm not sure that we want to do it all. I think that's a conversation we're going to have with GTEC and the labs that do the standards testing to see if we can find some, some efficiencies there.
Do the labs do that kind of interoperability testing?
I believe in some jurisdictions they do. In the places that we went to look, and Derek made this point to me when we were talking about this, in most of the jurisdictions, or in all of the jurisdictions actually that we went to visit that had central management systems, there was a lab doing, secondary interoperability testing for the central management system, at the commission or the the lottery headquarters. I'm not sure that that's the most efficient model. We're looking to, I think, not minimize the work, but I think we're looking to have the burden of the testing be on the labs that are doing it on our behalf. So I think it's something that's to be determined. I think we'll have a lab, and I think I'm going to look to GTEC to say what is going to make them comfortable that they can do complete testing to make sure that the devices that are coming into the jurisdiction don't cause any problems and work well with the CMS.
But then that test also has to be a test of the deployed machines in the configuration that they're deployed, that configuration interfacing with the CMS. That's
Yes.
probably the last piece of that, right?
Yeah. So that's what we're doing, with the labs, and I think it will, all things considered, I think will not end up being any kind of an encumbrance to, the critical path for opening Plainridge. We're going to have to do some workarounds. Bruce will have to work with the manufacturers to bring the inventory into that secured warehouse prior to testing, but I think that there was a lot of angst around these procedures that went out because people thought we were going to have to, nail them before they could ship product in. So we're working with them. I think it's an important message to get out.
So just in terms of process, the ITLs would respond to get certified. You'll do your thing and certify them. Then who chooses what what lab to go to?
So the business relationship in the case of the manufacturers, it's the manufacturer's choice who to do business with based on the cost. The remuneration is from the manufacturer to the lab to get the certificate that it meets our standards.
Right.
That having been said, it is the Commission's plan to engage in an open procurement one of the labs that we certify to assist us on a professional consulting basis. We need to certify the game floor as a part of the opening procedures. And I don't know, Frank Naborski is also here from Power Strategies, and I have to credit Frank with helping me with the process of not only, and Stephanie Maddox as well, another principal, with building the processes. What would you say is, in terms of opening a gaming floor, what support will we need from an ITL, CITL?
Well, generally, good afternoon, Council.
Good afternoon.
Generally, they come in and they will...
Identify yourself, please.
Frank.
I'm sorry, I'm Frank Naborski, Power Strategies. Generally, the certified independent test lab will come in and provide certification for the games, do the testing in accordance with the standards of the Commonwealth, perform any on-floor tests that may be necessary to ensure that the game communicates with the system from an accounting standpoint, and then likewise, the systems are communicating back with the CMS system to make sure that that information is being properly reported as well. They verify that the certification that they did in their lab, wherever that site may be, that the product, the programs, the software, firmware, and associated equipment that's included in the cabinet that was delivered and subsequently installed on the floor meets the standard and meets the criteria that they use to test, and everything is regulated and properly affirmed that it is what they tested and what's being installed on the floor.
So long answer, we'll be engaging labs to support us in some validation for opening, but on an ongoing basis, the relationship is between the manufacturers and the labs.
So they've been alerted of this time frame, which is a tight time frame, the ITLs.
Yes, I've kept them up. I think they were very anxiously awaiting having the applications to be able to fill out because they realized that that the time is short as well. So yes,
Great.
they were prepared. I really, I think, was looking to share in a general sense the overall business processes, the fact that we've received a lot of feedback and we've responded in the documents, and I think what we need to do now is take that first draft incorporate our responses into those, into the business processes, change them where necessary, and then come back out with another iteration. But it's a conversation. I'm really grateful to all the people that have participated, and both two of the premier labs in the country, along with a number of manufacturers, have willingly helped us. And again, these are not regulations; these are our business processes. But it makes sense to kind of have everybody be on the same page, to use best practices as we do this. The other thing that will come out of the eventual document is we will be able to understand where can we automate some of the handoff of this information. We'll certainly use the portal that was created for the licensing management system to allow manufacturers to apply for their permits. I think the data that comes from independent test labs that are our results and related to the configuration of machines, I see the need to populate that into the central management system. These are things we need to figure out. I don't think there is software that does this type of handoff, but whatever we can automate in our business processes with our partners is going to make doing business easier. And so I think underlying what we have here, what we get out is going to be really an articulation of how we're going to be doing business in what is a pretty complex relationship between us, the licensees, the manufacturers, and the testing labs. So that's the update. I entertain any questions on any of the material.
Well, I looked through this and read as much as I could. I got it yesterday. I have a couple of comments very small comments that I want to take up with you offline.
Okay.
I need not. But overall, I think this is really a thoughtful and thorough and highly detailed plan, and a very thoughtful treatment of all the issues that were raised by the people who commented on them.
Thank you.
And it's also, frankly, presented in a format that's easy to access and understand. So I think this is a first-rate job. I had a question, and I don't know whether we've resolved it, and we need not even take it up today, but I do think at some point we need to take it up if we haven't. Maybe I just forgot. And that is, what on a going forward basis is do we envision will be done by our lab and by independent outsiders? And I don't know that we've ever really sketched that out in a broad form. Maybe we have, and if we haven't, we certainly don't need to take that up today out of the blue, but I think we do need to think about that. I'd like to know about that.
Okay. I mean, I'd be more than happy to talk to that.
I think we have talked about this back when we made the decision, but it was a long time ago, and I certainly don't remember very much about it. And I don't really know what's happened other than this update. I've sort of lost track of whatever happened to the lab. So I think it might be, I had some of the same thoughts. I think it might be a good idea to put you on the agenda next session if we can, to just get an update, or you and Rick, to talk about why are we doing the lab? What is the interface?
Yeah.
What is the status, et cetera?
I'd be more than happy to give you that update.
Yeah, I think that'd be really helpful, particularly now since we're beginning to staff it up.
Yeah, well, I mean, I think it's a conversation. I did have I briefed Commissioners Cameron and Stebbins on, what we see using the space in the headquarters for, and why we're allocating space and what we're going to do. So I think let me prepare something that kind of articulates that in a way that everybody can understand, maybe some crayon drawings or something, and bring that back.
The second thing, and I do want to talk about this for a second, because I do want to make sure we're on the same page, is on page 3 of the application, which is page 125 of the packet. I don't know if we can bring that up. But it's a section that deals with the public records law. And the sentence that caught my eye there is, please note the commission will use its best efforts to protect any information it deems subject to an exemption. I'm concerned that that is inconsistent with our policy with respect to redactions. the policy with respect to redactions that we, or may be inconsistent with it, so I wanted to have this discussion. The policy with respect to redactions that we adopted not too long ago says that we will redact the things that the public records law requires us to redact. It does not say that we will redact and keep from public disclosure everything we are able under the Public Records Act to keep from public disclosure. And this is an issue that arose when we were dealing with the RFA2 applications and some of the RFA1 applications. And it seems to me that this is inconsistent with that policy. If we are saying that we will not release information that we are entitled to withhold under the Public Records Law, and the applicants rely on that when, in fact, we've said something different in the policy.
So we do have our redaction policy. The reality is, however, that we have very few exemptions to use anyways. So a lot of the information, I think what we'll have to do, John, is make clear to the people involved that while there are exemptions under the public records law, they don't apply to the vast majority of the information that we take in. So we really only will end up redacting the things that we are obligated to redact, which is generally personal type information. Right. And we just need to make that clear. I mean, many of our, we had an exemption for applicants when we took in the
Right.
RFA1 and RFA2. But that exemption only applies to applicants, and these folks don't fall into that.
Right.
So we just need to let them know what they're looking at so that they can plan accordingly.
So is it saying that you don't include any proprietary or IP that you don't want potentially publicly available, yes?
However you choose to phrase this, I'm
Okay.
just, and
right.
you need to
Yeah.
consult over that.
Yeah.
I just don't want to appear to overpromise here.
Right, okay.
And that can be a big deal.
Okay, well, let me circle back with Loretta and make sure I get the language right, because I really just took the form from IEB and put it in the package, so. I don't want to have something submitted that we then have to go
No,
back
that's
to them
right,
and say,
that's right.
you need to pull some of this out because it looks like
Right.
it's something you don't want everybody
Right.
to see, so,
Well, they may not be able to pull it out.
okay.
John, I had a quick question. It's under the document qualifications and conditions of
Okay.
certification. And it's just down at the top of page 8, which is page 117 of the packet.
Okay,
Number 11, shall allow up to 3 MGC employees to visit annually to inspect, and it talks about the laboratory covering our costs.
right, so,
I'm a little uneasy about that.
okay, well, so, first of all, I took liberally from Iowa's qualifications, so that's kind of the genesis of this. We made some changes to be specific to us. One of the things that we talked about with labs was we were going to certify them one time, and then they needed to reapply every year with any changes, and then they would give us up to $2,000 for remuneration for us to audit them. And I think what this is calling out is the ability to annually go and make sure that they are employing best practices in their record keeping and their testing methodologies in the work that they're doing on our behalf. And I mean, is it the fact that we're asking them to pay?
Well, I have no problems. I would view it as, if they're vendors of ours, I question whether there should be some restrictions on how many times we can visit and how many of our team can actually go out and visit. I just wasn't
Okay.
sure if the remuneration of, or reimbursement of, our travel or out-of-state car rent, that just doesn't
Yeah, I mean, I-
seem to blend with how we assess and have an operational budget.
And you know what, I certainly would be willing to make changes to that, like covering a trip for one person for an audit. I don't see a team of 3 people going, frankly. I think the gaming lab manager would want to make it a point to visit. Frankly, these labs conduct multiple sessions for regulators a year and invite us to participate, get together with your fellow regulators, let's talk about what best practices are. So I think there'll be opportunities for us to do those audits in New Jersey and in Las Vegas and not make it a burden. But I mean, I'll work with,
Let's just relook at that.
yeah, I mean, I'll definitely rework the language.
I agree.
Commissioner.
The
Yeah.
touching base, visiting their labs is, we've had an opportunity to do, I think, all 5 of us as commissioners it's a good sound business practice, but
Kind of wanted
this
to
wording didn't
institutionalize our
quite
right to
work
do
for
it once a year if we wanted to, so,
Okay.
regardless of who pays for the travel expenses.
John, you got a request from Derek Smith from Scientific Games to follow up with a conference call. Did you guys have that?
No, there wasn't enough time. He basically asked early this week. I've only talked with Global Cash, but I told Derek that I let him know that our responses would be in the packet and that we would talk subsequent to this meeting about our responses. So I will follow up with Derek. He's one of the people in the industry that I think has responded whenever we've asked, whether it's responsible gaming or for comments. And Derek is from Valley, which is now part of another company, Sci Games.
John, you have a lot of, this was a lot of work, first of all of these comments and responding to them. Did our consultants assist you with that?
In a great way, absolutely, yes.
And they will continue to assist you because you have a lot of to be reviewed.
Right.
So
It's a work in progress, and I think we need to get through it all. We need to have the back-end conversations with the people that gave us the original comments. In some cases, I think we're just going to make a decision that we're going to do it in one way. One particular cause of angst was the fact that we're requiring individual configurations, meaning a gaming machine, the software, the bill acceptor, the printer, to be treated as a single configuration. One of the questions was, can't we certify a bill acceptor and then just plug it in with a combination of whatever we want? And the answer is no, because I think in my view, and I'm open to interpretation here, a configuration is the combination of all of the components that make up the gaming system. So to say that a bill acceptor is certified, but without plugging it into the machine that it's working with and calling that the system, I think that's a mistake. It makes it more complex, and we may have to look at our permitting costs, because we charge $500 for a configuration, and that may be a little bit onerous when you look at the fact that we're going to be permitting individual combinations of the different devices. Most vendors, most licensees will choose one type of bill acceptor and one type of printer, so that's not that problematic. But that was one of the more, I think, substantive comments that bears additional.
Did that come from different people?
No, just from one.
Just one?
Yeah, I think
Aristocrat and IGT both mentioned it, I
they
believe.
did. Okay, all right. So that bears, further discussion.
Anything else?
Well, I too see that there's been a lot of work that has been done, in this realm, and I think that you're showing a lot of great progress. So
Thank you.
thank you.
Thank you. Item last is we have another round of candidates for the Gaming Lab manager position, some Skype interviews, and I'm hopeful there, so on that.
Good.
Thank you very much.
Okay.
Thank you.
All right, thank you. Director Day, I think we're at the end of the list.
I have nothing else.
Anybody else? All right, do we have a motion to adjourn?
So moved.
All in favor? Aye.
Aye.
All right,
Okay.
we are adjourned.